Good afternoon, Justice Martires. The records show that this is the first time that you have aspired for the Supreme Court. Is this accurate?
Found out that one of the applicants was Justice Jose Catral Mendoza, because I was one of those who was asking him to apply for the Supreme Court, and he kept on refusing. But when I really found out that he was finally convinced to apply, I had to withdraw my application.
That was quite some time ago.
Yes, Your Honor.
And it has, in fact, you have been in the Sandiganbayan since 2006?
2006, Your Honor.
And what made you decide to apply now?
Honestly, Your Honor, I was thinking of applying for the office of the Ombudsman because I heard that the Ombudsman was planning to retire early from the service. But when I heard that the Honorable Conchita Morales, Carpio Morales, decided not to retire, I instead applied for this vacancy of the Honorable Jose Perez.
You turned 68 in January. That's right?
Pardon, Your Honor.
You turned 68
Yes, Your
in
Honor.
January.
Yes, Your Honor.
Which would mean that should you be nominated and appointed, you shall serve the High Court only for 2 years.
Yes, Your Honor.
Okay. Assuming that you have 24 months, okay, do you think that it will be possible for you to finish the over 1,000 cases that are expected to be assigned to any justice who would assume the next vacancy in the Supreme Court within the 2-year period?
I always believe in miracle. I always believe in prayers, and I think with a little work, I might be able to reduce that 1,000 cases that is assigned to a particular justice, probably by half. That would depend on my health also. But I always, as I said, I always believe in prayers, and that's the only way I can discharge my duties and functions should I be appointed to the Supreme Court.
Since you mentioned health, how is your health? Have you had any procedure done on you lately?
Luckily, Your Honor, I have not undergone any procedure. The only medication I'm taking is Losartan, which my cardiologist prescribed me to take, because he said that when a person reaches the age of 50, you have to take some maintenance medicine to regularize your blood pressure.
Thank you, Justice. Now, the records will show that before you became a Sandiganbayan Justice, you were an RTC judge.
Yes, Your Honor.
And prior to that, you were in the private practice of law, and you were also an assistant department manager, legal department of the Ministry of Human Settlement.
Yes, Your Honor.
Now, considering that most of the cases that you're handling now are graft cases, so there has been, well, your exposure now to labor law cases and even other fields of law are quite limited. How have you prepared for the other cases that you would have to deal with or to take action on should you be appointed to the Supreme Court, such as cases on taxation, cases involving other fields of law other than graft cases?
A case before the Sandiganbayan was filed involving the Development Bank of the Philippines. The defendants there were the chair, Rinaldo David, and a private citizen by the name of Roberto Ongpin. That case involved some issues on um, about taxation and its relation to insider trading. I was able to decide that case properly insofar as I am concerned. But to keep me abreast also, whenever I have the time, I try to read decisions of the Supreme Court on some important matters or events or cases that is being decided by the Supreme Court.
Are you computer savvy? Are you computer literate?
I encode my decisions personally. I only know about Word. I can do research from the internet. That's what I do, Your Honor.
With regard to case management, how do you determine which decisions to prepare for, or how do you determine which cases which have already been submitted for decision to work on first?
I just assume the chairmanship of the second division, where I have the, should I say, the power to manage the caseload of the division. I work on which of these cases had first been submitted for decision and give it a priority before other cases submitted for decision should be decided by the court. So in short, the first in, first out is the policy that I adopt at present, Your Honor.
How much reliance do you have on the use of technology in helping you manage your court docket?
Well, I always, actually, I do supervise it personally, the Office of the Clerk of Court. I always want to be informed daily on the pleadings that are submitted by the parties, so that if these pleadings can immediately be decided by the court, like motions for extensions of time, I immediately dispose of that, so that the matter of being heard on a motion day should be dispensed with, and the court will be given more ample time to concentrate on other matters.
For the cases that are assigned to you, how much time does it take you usually to do an extended resolution, not just on postponements, something that would require more substantial content?
I think there are times when it depends on the case and on the issues involved and the documents or the evidence is presented. It takes me about between 3 to 6 months to decide a case that are complicated, or that is complicated, I'm sorry.
Including resolutions?
Depends again on the resolutions. If it is just a matter of a motion to file demurrer to evidence, and I decided to deny that, it only takes me about a week or 2 weeks to deny that demurrer to evidence. But if I have to grant the demurrer to evidence, I have to study that carefully, because I have to discuss the reasons for the granting of the demurrer.
Thank you, Justice. In the case of People versus Carlos Flores Garcia, I believe you penned this, and you began by saying, and I quote, "The law must not just be spoken as written, it must be administered and enforced according to its letter and spirit," end of quote. As the interpreter of laws, the Supreme Court decisions are jurisprudence and form part of the law of the land. Do you agree that the Supreme Court commits errors every now and then, and how would you avoid this should you be appointed to the High Court?
I would agree that sometimes the Supreme Court commits errors. I have a case that I decided when I was a presiding judge in Agoo, La Union. I convicted the accused for murder, When the case was brought to the Court of Appeals, the decision was modified to frustrated murder. And when the case finally reached the Supreme Court, the decision was the accused is only guilty of serious physical injuries. But the victim in that case died. So I would say that the decision that the Supreme Court made an error. To avoid this, I always try to read the records of the case. I do not rely on my researchers to give me a statement of facts. Even on jurisprudence, when I ask them to make a research for me, I always ask them to hand me over the decision that they are citing in a particular case. To borrow the lingo of the Tagalogs, nagiging sigurista lang ho ako.
Thank you, Justice. And I have the warning light there, so this is my last question. Actually, it is based on a comment made by one of our respondents. Is it true that they made a courtesy call to the President? Why was it necessary for them to make a courtesy call? Were they not concerned that it might affect their independence? Was he contemplating rather that he would be aspiring for the High Court? Would you care to comment?
In all honesty, Your Honor, I did not make a courtesy call to the President. Neither did Justices Fernandez, Ekong, and Queiroz make that courtesy call. We went to Davao City to conduct a out-of-town hearing. We arrived in Davao on a Sunday. We were informed that afternoon when we arrived that the President was going back to Manila. On Tuesday, I was asked by one of the justices if I am willing to see the President. And naturally, any person in his sane mind will always say, yes. Who am I to say I don't like to see the President? So I said yes. I said, why? He said the President would like to meet us on Thursday. I said, how would it be possible when the President is in Manila? He said, no, the President is going back to Davao on Thursday because I think Wednesday he was scheduled to go to Jolo or one of these towns in Mindanao. So Thursday we were on our way to the President's office at the Department of Public Works when suddenly I received a text message from Justice Teresita Baldos, now retired from the Sandiganbayan, telling me that, wow, you are going to see the President. So I asked her, where did you get that news? She said, it is now through DZMM, double M. And then a few seconds, my wife also texted me that said, so you're going to see President Duterte. I said, where did you hear that? She said, also from ABS-CBN. On our way, I hope that event was recorded. I was really angry. I was angry at the President's men, especially the ones handling the media, for leaking this information to the media. I was telling the other justices that I will confront whoever is handling the media affairs of the President, that this is a private affair. This is a private invitation from the President. It will give a very bad impression to the public that we are going there because the President is going to ask us for something. We did talk to the President that evening. We spent 4 hours with him, but not a single case did the President ask us what that case is all about. The President only told us about his war on drugs. He told us about his student days, his life as a student. He told us about his experience within Justice Solidum as his professor. He told us about the history of the Muslims. Nothing. Actually, the president told us that I respect the judiciary. I will never interfere in the affairs of the judiciary. But honestly, Your Honor, I almost did not join the group that evening who went to see the president. And I think the justices who were with me could attest to that, Your Honor.
As I mentioned, Justice Martires, that was my last question, and good luck.
Thank you very much, Your Honor.
Thank you, Madam Chair.
Thank you, Attorney Cayosa. May we request now Attorney Mejia to continue.
Thank you, Madam Chair. Good afternoon.
Good afternoon, Your
Justice
Honor.
Martires. Let me just, in connection with that particular incident where you met under those circumstances with the president, and given the opportunity now to explain your side, what assurance can you give this body that you will maintain your independence should you be appointed as the next, as one of the associate justices of the Supreme Court?
I have always maintained my independence, even before I joined the judiciary. I used to work, or I worked with the Ministry of Human Settlements. My superiors there could not tell me what to do, especially when it comes to legal matters. It is very unfortunate that after the EDSA revolution, people kept telling me that I am pro-Marcos. But during the time of Marcos, I was really on the streets, joining rallies and demonstrations. When President Aquino became president, I'm referring to the son, they also had been telling me that I am pro-GMA. But as I had said in one of my decisions, that the court should not be influenced by any king or president. We should only rely and make our decisions pursuant to the evidences presented and the applicable law. I have maintained my independence in the Garcia case, even if it meant that President Benigno Simeon Aquino III was mad at the Sandiganbayan, particularly at me and Justice Baldos. I insisted on what was right, or what is right, and I didn't care what Malacanang would do to us. I even heard that I was the subject of a background investigation, whether I earned from that case or not. But I maintained what I thought was right. I insisted that the office of the Solicitor General cannot intervene or appear before the Sandiganbayan.
Thank you. What do you think are the major problems plaguing the judiciary today?
There is only one problem that two problems. One is corruption, and the other one is the perceived interference of some government officials, and actually, if I may add, the trial by publicity of which media plays a very important role. These are the problems that the judiciary is facing these days, Your Honor.
How do you intend to address this should you be lucky enough to be appointed as one of the associate justices?
We cannot correct public opinion, especially what media would write. A reporter may submit his report to his editors, but the editor can always edit the report of a particular field reporter. We cannot over time change the judiciary by putting in honest officials or honest judges. It is very hard to determine at first who will be honest and who will not be honest. The lure of money is very tempting. It takes someone to be able to say no to accept a gift or money in consideration of a case.
Tweeted question just came in, and this will be my final question. You were admonished by the Supreme Court on January 15, 2013. Why should the JBC not consider that against your application?
When I was first appointed to the Sandiganbayan, one procedure that the Sandiganbayan was adopting was to schedule an execution of judgment. I asked my chair, Presiding Justice Edelberto Sandoval, that this is the only instance where we have to schedule an execution of judgment which is not provided for under the rules on criminal procedure. But I was told by Justice Sandoval that this practice by the Sandiganbayan was adopted during the time of then Presiding Justice Francis Garcia-Torena, who according to him wanted to give the accused all the chances of availing of whatever remedy there is. So I knew we were violating the rule, because and so far as I am concerned, once the Supreme Court issues an entry of judgment, there is nothing more for the lower court to do but to issue a mittimus. When I was transferred to the 3rd Division, there was this case of Velasco, where the Supreme Court, in that case, where the accused filed a petition for certiorari before the Supreme Court. The accused was convicted by the Sandiganbayan. The Supreme Court dismissed the petition for certiorari. The accused filed a motion for reconsideration. The Supreme Court denied the motion for reconsideration. The accused filed the second motion for reconsideration. Again, the Supreme Court denied the second motion for reconsideration. The accused changed his counsel, and the new counsel filed another petition for certiorari. When that petition for certiorari was filed, the Supreme Court directed the Office of the Solicitor General as well as the Office of the Special Prosecutor of the Ombudsman to file its comments. And then the Supreme Court referred the matter to the en banc. Justices Villaruz and Queiroz, including myself, were of the impression that the Supreme Court might give due course to the second petition for certiorari because it was referred to the en banc. In the meantime, a complaint was filed against us by the private complainant in the criminal case. The en banc denied the second petition for certiorari. We explained to the Supreme Court that we could not execute the judgment because the Supreme Court has entertained the petition for certiorari when it could have outrightly dismissed the second petition. I explained also in my own reply that we are not covered by Rule 65, that we have to await for a temporary restraining order in order for us to proceed, because the decision has already been promulgated, and therefore there is nothing for the Supreme Court to restrain us from doing. The decision of Justice Bernabe said that we should have waited for a temporary restraining order, but because there was none, we should have proceeded with the execution. But I said this is no longer covered by Rule 65. In criminal actions, The proceedings start from the arraignment of the accused to the promulgation of the decision. We were just awaiting the finality of judgment from the Supreme Court and the final entry. There is no temporary restraining order. And we also said that had the Supreme Court granted the second petition for certiorari, reversed the findings of the Sandiganbayan convicting the accused, and in the meantime we sent the accused to the national believed prisons, can we unwind what we have done? In a worse scenario, Justice Villeros, may his soul rest in peace, said that supposing it was a death penalty and we executed that, how do we now bring to life an accused using the ponencia of Justice Bernabe? We took it, we accepted that decision. We cannot do anything. That was the view of Justice Bernabe when we were admonished in that case.
That was my final question. Thank you and good luck, Justice Martires. And thank you, Madam Chair.
Thank you very
so
much, Your Honor.
Attorney Mejia. May we call now Judge Ilaw to continue.
Thank you, Justice Gutierrez. Good afternoon, Justice Martires. And how are you today?
I am okay, Your Honor. I'm good.
All right, as an Associate Justice of the Sandiganbayan, incidentally, Sandiganbayan has a limited jurisdiction. Would your knowledge in law in connection with the Sandiganbayan cases and your experience as such will be enough for you to be nominated as an Associate Justice of the Supreme Court?
With no offense meant to anyone, Your Honor, I think my experience as a presiding judge of the Regional Trial Court, and now with my 10 years in the Sandiganbayan, I think I am in a better position than those who came from private practice, who came from the corporate world. I think I have now a better perspective and a better grasp of how cases should be decided, of how it should be treated, of how to think of the welfare of the citizenry vis-a-vis the issues of a particular case, Your Honor.
All right, you singled out private practitioners. How about those associate justices in the Court of Appeals eyeing or jacking a position as associate justice of the Supreme Court?
The associate justices of the court, I'm sorry, Your Honor, nobody has a monopoly of knowledge. All of us went through 4 years in the College of Law, and I guess the Supreme Court or the Court of Appeals justices are very much also qualified to go to the Supreme Court. If I cannot compare myself to any one of them, I would even say that they might be intellectually better than I am. I could only compare myself to them when it comes to morals, and I could say that probably I am on par with them when it comes to morality. But when it comes to intelligence, I would say that I probably would submit to them and say that they are probably intellectually better than I am.
All right, you have been unanimously endorsed by the Integrated Bar of the Philippines Quezon City Chapter to become an Associate Justice of the Supreme Court. How and why do you think you were able to garner the unanimous vote among the members of the IBP Quezon City Chapter? Did you campaign for it?
I think most of the officers of the Quezon City Integrated Bar of the Philippines Chapter, the Quezon City Chapter, most of them have cases before the Sandiganbayan, and most of them had a chance to observe my demeanor in court. I think most of them are happy with the decisions that I have made. with the rulings that I have made when I am presiding, most of them probably, I could only say probably, are contented, especially with my dissenting opinions. Although I would say that one of the officers there, Donna Alagar, who is one of those who endorsed me, lost the case before the 3rd Division. So probably the only reason why it was unanimous is because they have full trust in me. That is my guess, Your Honor.
All right. The letter also commended your competent management of the court. Can you elaborate on this?
I never allowed counsels to argue for more than 5 minutes. I always make a ruling immediately when an objection is raised. Probably that is what the referred to as court management, Your Honor.
Competent as well as sound management.
I cannot that is the words of the officers of the Integrated Bar of the Philippines, Your Honor. Probably that is their view, that I am a competent justice of the Sandiganbayan, especially during trials. Competent when I write my decisions. It is supported by the facts and the law. I don't know, Your Honor, that's probably how they view my conduct as a justice of the Sandiganbayan.
There is a Twitter question, maybe in general, have addressed to you, Justice Martires. Have anyone ever approached you to influence your decision on a case?
If I say no, Your Honor, I'd be a liar. Yes.
And
even when I was a judge, Your Honor, a lot of people would come to me trying to talk to me about a particular case.
And how did you handle it?
I remember clearly when I was a judge in Agoo, when an accused in a rape case was one of the trusted bodyguards of the mayor of Agoo. Some of the bodyguards of the mayor talked to me, tried to influence my decision by telling me that there was no rape. They were telling me that the victim was actually the girlfriend of the accused. I knew the accused was very close to the politicians in Agoo, but I still convicted the accused, despite the influence and the threats that I received from some of his friends. I was also told when I was writing my decision in a particular case, I'd like to remember that. Yeah, there was a case. I forgot the title of that case, but there was a case when I was being offered 1 million pesos just for me to acquit the accused. I said, if it is 1 billion, I will accept it. I convicted the accused, and it is subject of an appeal to the Supreme Court.
Why the offer is low?
1 million is very low for me, Your Honor. Although I don't have 1 million pesos, I'd like to secure my family with a 1 billion. I can live in Europe, in one of the countries, probably Lithuania or Latvia, and if I have 1 billion pesos, I can easily go anywhere in the world.
And I presume that you may have displeased many politicians in your career as an Associate Justice of the Sandiganbayan. Is this true?
Pardon, Your Honor?
You may have displeased politicians. Displeased, please. Displeased.
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 I am displeased with the Sandiganbayan.
No, politicians.
Oh, I respect these politicians, and in fact, no politician has ever tried to influence me or talk to me. And it surprises me that none of these politicians came to me. The case I am talking about only refers to a case of a municipal mayor in Luzon. The one who talked to me is a retired government official, not a politician. But none of the politicians, I think, because, you know, Your Honor, I don't think I have displeased any of the accused that I have convicted, because a criminal, as far as I'm concerned, knows the crime that he has committed. The criminal would only hope that the prosecution will make a mistake, and that mistake might eventually result in the acquittal of the accused.
What did you learn from your seminar on corruption, detection, prevention, suppression in Paris, France? Have you applied your learnings at the Sandiganbayan?
One particular aspect of that seminar that I learned is that there is a gender difference in corruption, that women are less corrupt than men. This is actually findings of some of the researchers of the World Bank. They say that women views corruption as risky. Women are highly moral than men. Women, the research paper says, are strongly influenced by moral values or by their peers. Women do not belong to exclusive men's group on corruption, and no women's group has ever formed an all-female corruption group. This is one thing that I learned. I also learned that there are two types of corruption. One is the political corruption, and the other one is bureaucratic corruption. I also learned that, like the Philippines, France is also corrupt, especially Marseille, a city in south of France. So I was of the impression that corruption is not the sole domain of the Filipinos or of the Philippines.
Is that not gender insensitivity? Would male magistrates agree to your observation and learnings?
This is a report of the World Bank on corruption, and I tend to agree with that report, that female in government service are less corrupt than their male counterparts.
The council, this August body is balanced. We have 2 women and 2 males.
I think the 2 members, Your Honor, are the exceptions to this all-male club.
Alright, what is the general tenor of your rulings on cases regarding violations of Republic Act 3019, the anti-graft and corrupt practices?
My view, the tenor of my rulings, actually, Your Honor, I have more acquittals than convictions with respect to cases before the Sandiganbayan. With no offense meant to the Commission on Audit, if only the lawyers representing the accused in most of the cases pending before the Sandiganbayan that were filed by the Commission on Audit. If only the lawyers would study the rules and regulations of the Commission on Audit, I think between 85 to 90% of the cases filed by the Commission on Audit before the Sandiganbayan will be dismissed.
That's how you measure
Yes, Your
legally
Honor.
and personally in acquitting or convicting an accused so that you could sleep soundly at night?
I think it is better to acquit when you have doubts than to convict, Your Honor. A person who is guilty and later on acquitted at least is the one who will suffer. An accused who has been acquitted but is actually guilty will actually suffer for the rest of his life. He will be haunted by that one indiscretion moment in his life. I could sleep soundly because I know I did nothing wrong in acquitting any of these accused. And if I go back again to my observations on the Commission on Audit, Your Honor, just recently the 5th Division, where I was appointed as a special member in the case, granted the demurrer to evidence of then Mayor Elinita Binay. I concord with the ponencia of Justice Horado. The case arose from an audit conducted by the Commission on Audit with the team leader Heidi Luce Mendoza, now with the United Nations. The audit was conducted when the Makati City Hall
My time
building.
is up. Only one last question, please.
Yes, Your Honor.
Alright, do you think you were able to live up to your promise in treating Senator Enrique's case with fairness?
Yes, Your Honor. Insofar as that aspect only of the Bill of Particulars is concerned. But now, Your Honor, I am out of the Enrique case because I am now with the 2nd Division, and the case of Senator Juan Ponce Enrile is still with the 3rd Division. Although the motion to quash filed by Lucila Gigi Reyes, I am still part of the division when that motion to quash was submitted for resolution.
Which shows allegedly your integrity, competence, probity, and independence, Justice?
We have not yet decided the motion to quash on Lucila Reyes. On the Enrile case, Your Honor, I only participated up to the extent of the Bill of Particulars where the court denied the motion of Senator Enrile, and which resolution was reversed by the Supreme Court.
All right, thank you very much. No further questions. Good luck, Justice Martires.
Thank you very much, Your Honor.
Thank you, Judge Ilaw. And now my turn. Good afternoon again, Justice.
Good afternoon, Justice Gutierrez.
Okay. You know, one of the rules of the JBC in determining the qualifications of candidates for nomination is to determine their mastery of laws, rules, and jurisprudence. So, I have just few questions on legal points. The Supreme Court recently promulgated 2 decisions in cases from the Sandiganbayan appeal to the Supreme Court. I'm referring to the case involving former President GMA. Of course, you have read the decision of the Supreme Court.
Yes, Your Honor.
Actually granting the mirror to evidence and acquitting GMA. If you are a member of that court, would you have concurred or dissented?
If I were a member of the 1st Division who first denied the demurrer to evidence of President Gloria Macapagal Arroyo, I would have joined Justice Ponferrada, who dissented from the resolution of the court.
The question is, would you have, if you were a member of the Supreme Court, would you have concurred or dissented in its decision?
Yes, Your Honor.
We are now in the Supreme Court,
Yes, Your
not
Honor.
in the Sandigan.
Yes, Your Honor.
You are concurring,
I will concur that the case
and
against
therefore, in effect, you are granting
the demurrer,
the
Your
demurrer
Honor.
to evidence.
Yes, Your Honor.
You were not a part of the division.
No, Your Honor.
Have you read the facts and the evidence presented before the Sandiganbayan?
Not entirely, Your Honor, but the issue, I think, in the Gloria Macapagal Arroyo case was the amassing of wealth.
365 million. And in view of... So you are concurring? Why?
I will concur, Your Honor, because
Why just...
there is no proof, Your Honor, that the President amassed wealth. A series, because in amassing of wealth, it must be a series or combination of acts, Your Honor. That is the definition in the plunder case. It is just the amount is not, the threshold amount of 50 million is not the determining factor. The determining factor, Your Honor, in the amassing of wealth is that it must be done through a series or combination of acts. If there was only one act done, even if the amount involved is 1 billion pesos, Your Honor, there is no plunder.
But have you read the decision of the Supreme Court?
Not in its entirety, Your Honor.
Therefore, you cannot, analyze the evidence before us now.
Not really,
You
not,
should
not
read it
intelligent, Your
first
Honor.
before you can conclude that you are concurring. How about the case of Senator Enrile, where the motion before the Sandiganbayan by his lawyer was only to fix bail, and the decision or resolution was that the motion is premature. Now the case reached the Supreme Court, and the Supreme Court granted bail even if there was no hearing before the Sandiganbayan to determine whether or not the evidence was strong. Again, if you were a member of the Supreme Court, would you have concurred or dissented?
In the motion of...
How you will decide cases when you reach the Supreme Court?
I read the ponencia of Justice Bersamin on the bail petition of Senator Enrile, and it did not deal so much on the legal issues, Your Honor, but more on the health of the accused. In the motion to fix bail that was filed before the Sandiganbayan, I was asking the counsel of Senator Enrile if that motion to fix bail could be considered as a petition for bail and if they were willing to join. Had Attorney Mendoza, the counsel of Senator Enrile, considered that motion to fix bail as a petition for bail, honestly, Your Honor, with the evidence that was presented by the prosecution in the petition for bail of Napolis, I would have also granted the petition for bail of Senator Juan Ponce Enrile.
Let us go back to the constitutional provision and the provision under the rules. These provisions were not relied upon by the Supreme Court because under the Constitution, all accused are entitled to bail except those charged with capital offense when the evidence of guilt is strong. As I said, there was no hearing, and the motion was only to fix bail on the grounds that there are two mitigating circumstances. Number one is voluntary surrender, and number two is his age. Now, if you were a member, again, this question of the court or the ponente, how would you decide?
With all due respect to Justice Bersamin, I think I will dissent from the ponencia of Justice Bersamin.
You will?
I will dissent, Your Honor.
Okay. Very good. On what grounds, Justice?
The mitigating circumstances that was being cited by the accused Enrile should not be ground for granting bail, because the rules of court is very clear that in the denial of bail, there must be strong evidence to deny a petition for bail. The rules of court never mentioned about considering mitigating circumstances or age as a factor in granting a petition for bail. The rules of court tells us that in the granting of a petition for bail, the court must rely on the evidences presented by the prosecution during the hearing of the petition. So if I were a member of the court that granted that petition for bail of Senator Enrile, I would have dissented, Your Honor, from the ponencia of Justice Bersamin.
Yes, because the decision was not based on the constitutional provision or the provision under the rules of court. Okay, let's now come to the decision of the Supreme Court with respect to this, or in the case of Marcos burial. Okay, again, the same question. If you were a member of the High Court, would you have dissented or concurred in each decision declaring that President Duterte, in announcing that the president or the former president may be entered in the libingan ng mga bayani, did not violate any law or jurisprudence? In other words, he did not commit any grave abuse of discretion.
I had a chance to read the digest of the ponencia and the separate concurring opinion of Justice Jose Catral Mendoza, as well as the dissenting opinion of Chief Justice Maria Lourdes Sereno. I would rather concur with the separate opinion of Justice Mendoza that this is more of a political issue than a justiciable one, that it is the President's prerogative to determine who should be buried in the libingan ng mga bayani for as long as that person complies or falls under the provisions of the law and who should be buried in the libingan ng mga bayani.
Dissenting, concurring.
I will be concurring with Justice Mendoza, Your Honor, that it is
Saying
more
that
of a
the issue is political.
It's more political, Your Honor.
You know, there are several issues, not only political. For example, the locus standi, whether or not, you know, under substantive issue, whether it's political. But, you know, if you read the ponencia written by Justice Peralta, he discussed the reasons why the former president should be entered in the libingan ng mga bayani. Two reasons, according to him, because he based his conclusion not on any law, but on the Armed Forces of the Philippines Regulation G number 1313765, enumerating the deceased or names of those people who are entitled to be entered into the libingan ng mga bayani. Among them are presidents or commanders-in-chiefs, secretaries of the National Defense, chief of staffs, etc., etc. But there are two exceptions. Those who were dishonorably discharged from the service. And number two, those convicted with crimes involving moral turpitude. And so, in the dissent of Justice Carpio, he said, the president was dishonorably discharged by the people themselves during the EDSA revolution. Although he was not convicted by the court of crimes involving moral turpitude, but he committed serious offenses like murder, torture, so many other offenses. So this is the dissenting opinion of Justice Carpio. So given these facts, would you have sided with Justice Peralta, saying that he was not dishonorably discharged because he did not commit any offense under the Articles of War? There was no proceedings before any martial law that he was discharged dishonorably. Number two, the president was not convicted in any court of any crime involving moral turpitude. So these are the basic issues in this decision. Now, what is your opinion, Justice? Who is correct?
I would say, Your Honor,
Would you
that
have concurred with Justice Peralta or with Justice Carpio?
I would have concurred with Justice Peralta if that was the case, Your Honor, because I don't believe that the former President Marcos was dishonorably discharged by the Filipino people. When we talk of one dishonorably discharged from the service, especially in the military, we talk of a decision of the court-martial that discharges dishonorably a member of the armed forces of the Philippines. This is not the case of Ferdinand Marcos. It has always been my belief that the president or the former president was not actually ousted by the Filipino people, but he opted to obtain peace. He opted to leave Malacanang and go to Hawaii just to obviate or prevent any untoward incident that may happen in EDSA. So I don't think that it was the Filipino people. If the Filipino people were able to force the president from leaving Malacanang, it was probably part of it, Your Honor. No, Your Honor, I am from Samar.
You're from Samar. But because of that revolution, because of you are changing history, because of
That is my belief,
it's a
Your Honor.
revolution. That's your personal belief. He was driven away. And in fact, in one of the cases decided by the Supreme Court, Manglapos case, remember?
Yes,
The
Your
Supreme
Honor.
Court itself declared that Marcos is a dictator, and that's why he was forced to leave the country. Anyway, you have your personal view, but I still am dissenting against the decision of Justice Peralta. Okay.
Well, as I said, Your Honor, if I may, I would have concurred with the separate opinion of Justice Mendoza, and just concur in the results probably of the ponencia of Justice Peralta, but more on the, I would concur on more on the decision or the separate opinion of Justice Mendoza.
I believe that's not only a political issue. It involves, in fact, the people. It involves questions of law. Whether or not, President Duterte acted on the basis of the present regulation, as what I mentioned before. Sometimes the Supreme Court, in answer to the question of Attorney Cayosa, commits errors.
Yes, Your Honor.
And I agree with you. Can you cite at least two decisions wherein you believe the Supreme Court committed errors?
One of the decision is that decision where a case for murder, the victim died, and the Supreme Court said the crime committed is only serious physical injuries.
Anyway, the JBC wants to know a landmark decision.
One of the decisions that apparently the Supreme Court made a mistake, and which actually is still the subject matter now of discussions among law students, is the case of Javillana versus Executive Secretary.
What is that case all about?
This is all about the whether or not the 1973 Constitution already took effect.
Javillana.
Javillana, yes, Your Honor.
In fact, that is the most disastrous decision ever rendered by our Supreme Court. Okay, the red light is there warning me to stop. Okay, thank you, Justice, and good luck.
Thank you very much, Your Honors. Thank you.